Sorry for the delay, everyone. So this is the third lecture in the series on the Bill of Rights and the amendments. So we are now 3 weeks into 2001. And already we've had an insurrection, an impeachment, and an inauguration. Oh my goodness, this is going to be quite a start to this new year. So last week, we looked at the Second, Third, and Fourth Amendments. Now, one of the most basic functions of any government is to punish those who are guilty of violent or forceful crimes. But the framers of the Constitution were concerned about, they wanted to ensure that people are not convicted of crimes that they had not committed. And therefore, Amendments 4 through 8 are dedicated to protecting the rights of the accused. Last week, we looked at the Fourth Amendment, which provides guarantees against unreasonable searches and seizures and requires probable cause for the issuance of search and arrest warrants. So today, we're going to examine other parts of the Bill of Rights that protect those who are accused of crimes. We're going to begin with the Fifth Amendment, which is the longest amendment in the Bill of Rights. It contains a hodgepodge of provisions that limits the power of the government to take action against individuals. It guarantees 5 specific rights of a very diverse nature. And so the right against self-incrimination in criminal cases. It provides protection for the right to have serious charges screened by a grand jury. It contains the right to avoid being tried twice for the same crime, and the right to the due process of law, and the right to receive compensation when private property is taken for public use. So let us take a look exactly what the Fifth Amendment states. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Nor shall anyone be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So that is a mouthful. So let's take it apart clause by clause. So the first clause. If we look at this clause, it gives civilians who are accused of serious crimes the right to a grand jury. And a grand jury convenes for the purpose of determining if there's enough evidence in order to prosecute. If the grand jury believes that the prosecutor has sufficient evidence, it will issue an indictment formally charging the accused with a crime. Now, the whole idea of a grand jury originated in England in the 12th century. It was intended to limit the government's power to charge defendants with a crime unless justified by evidence. Now, a grand jury meets in secret, and only the prosecutor is allowed to present evidence. Now, secrecy is critical to protect the reputation of people who may not ultimately be indicted.
No, with people who are Tennessee, they came from Tennessee, yeah.
I'm sorry.
But where, Josh, where is it?
Okay, so if everyone could mute their microphones.
And it's a bond?
We'll have time for.
I see who is, okay.
We have time for questions at the end.
Okay, I think we've got everybody muted. Sometimes people don't realize they're unmuted. Okay.
So testimony in grand juries is secret to protect the reputation of people who may not be indicted. And you may remember that the Mueller report redacted testimony that was given to the grand jury because that did not result in an indictment. Some people would say, unfortunately. Another part of the Fifth Amendment is, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Now, once a defendant has been acquitted, the Fifth Amendment forbids the defendant from being tried again. That would be double jeopardy. Now, the double jeopardy clause specifically addresses endangering life and limb. Now, that is a reference to a colonial era practice of punishing crimes by cutting off ears or damaging limbs of the convicted. Now, double jeopardy doesn't apply when the accused is retried because of a previous mistrial in which the jury was not able to reach a verdict. So if there's a mistrial, then the defendant can be tried again. Nor is it a violation of double jeopardy for the defendant to be granted a new trial on appeal. So if the defendant is found guilty by a lower court, he or she can appeal and would then be retried again. However, if the defendant is found not guilty in a lower court, the prosecution cannot appeal for another trial. And double jeopardy does not apply in civil cases that arise from a criminal act, such as when the family of a murder victim sues the alleged killer for monetary damages, even if the accused was acquitted of the crime. And that is exactly what happened in the case of O.J. Simpson. He was acquitted in criminal court, but a civil court jury ordered him to pay $25 million in damages to the families of Nicole Brown and Ron Goldman. Now, another part of the Fifth Amendment says, nor shall anyone be compelled in any criminal case to be a witness against himself. This provision is known as the right against self-incrimination. It's based on the principle that in American law, the defendant is presumed to be innocent until proven guilty, and that the state may not demand that the accused testify against himself or herself. Now, the Supreme Court has ruled that in order for a confession to be admitted in court as evidence, it must truly be voluntary. As a result, the court has overturned convictions based on forced confessions obtained through physical coercion or third-degree tactics. In Miranda versus Arizona, the court held that coercion is inherent to some degree in any questioning by police of an arrested person. So the background of this case is that in 1966, Ernesto Miranda was convicted in Arizona of kidnap and rape based on confessions that he made after 2 hours of questioning at the police precinct. But he was not told about his Fifth Amendment right to remain silent. And so ultimately the court overturned the conviction, ruling that a police interrogation is inherently intimidating. And so under those conditions, Miranda's statement of guilt could not be considered as given of his own free choice. And so the court held that a defendant must be made aware of his or her rights when arrested. And that leads to the Miranda warning, that when a person is arrested, the arresting officer has to read these 5 rights. You have the right to remain silent, which means that anything you say can and will be used against you in a court of law. Clearly, you have the right to an attorney, and if you can't afford an attorney, one will be provided with you. But there are limits to these Miranda warnings. And so, in a subsequent case, Illinois versus Perkins, the court ruled that Miranda warnings were not required when a jailed suspect confesses to a police officer posing as an inmate. The court held that conversations between suspects and undercover officers are not afforded Miranda protection since they're not done in a police-dominated atmosphere where compulsion to confess is present. And so the Miranda decision protects suspects from coercion, but not from deception. If the government grants a witness immunity from prosecution, it can force a witness to testify. Now, there are two types of immunity. There's total immunity, which protects the witness from any prosecution resulting from his or her testimony. And there's also something called use immunity, which gives the government the right to prosecute the witness based on evidence discovered independently of the testimony given. Now, the Fifth Amendment also says, nor can anyone be deprived of life, liberty, or property without due process of law. And that means that the government may not behave arbitrarily or capriciously. It must act fairly according to established rules. Now, the Supreme Court has ruled that government must follow fair procedures in both criminal and civil cases in order to safeguard the individual against the power of the state. So due process rights includes the right to the presumption of innocence and to have the government prove its case beyond a reasonable doubt. Another right contained in the Fifth Amendment, in addition to due process, is that nor shall the private property be taken for public use without just compensation. The just compensation clause limits the power of the government to take private property for public use without giving the owner some compensation. And so this cartoon shows the protection against governments taking property away without offering just compensation, which is eminent domain. Under the Fifth Amendment, any taking of private property must be for public use. The government only has to pay an owner fair market value of the property. Government does not have to pay moving expenses or replacement costs in another neighborhood. Okay, so now let us move to the Sixth Amendment, which was added to the Constitution to guarantee that criminal defendants receive a fair trial. It attempts to balance the enormous power of the state, which pays both police and prosecutors to prove guilt, against the power of the individual to prove his or her innocence. So the Sixth Amendment reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed of the nature and causes of the accusation. Now, it goes on to say that the accused has the right to confront the witnesses against him and to have compulsory process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. Now, there are 8 distinct rights included in this amendment. So as we did with the Fifth Amendment, we will dissect the Sixth Amendment clause by clause. So in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Although it refers to all criminal proceedings, its protections do not always apply to every minor offense, such as jaywalking or speeding. The defendant must be brought to trial quickly because, as legal scholars say, justice delayed is justice denied. Although a person is assumed by the law to be innocent until proven guilty, a long delay before a trial can damage a person's reputation. And so the Sixth Amendment ensures that the defendant does not languish in jail. Now, if the prosecution does not bring the case to trial in a speedy manner, then it must drop the charges against the defendant, in effect, giving the defendant a get out of jail free card. Now, Congress enacted fixed time limits for the federal government to bring criminal charges. This was done by Congress in the Speedy Trial Act of 1974, which states the time between a person's arrest and the beginning of his or her federal criminal trial that should not exceed more than 100 days, with the exception that if the defendant must undergo extensive mental tests or when the defendant or a key witness is ill. Now, currently, many immigrants on the southern border have been held in detention for more than 100 days. But unlike criminal defendants who are citizens, non-citizens have no Sixth Amendment rights to a speedy trial. Now, besides a speedy trial, the defendant is also entitled to a public trial. In England, to suppress dissent in the 1630s, King Charles I used a special court that met in secret. It was called the Star Chamber, and it became notorious for its arbitrary methods and severe punishment. And so the court was named the Star Chamber because it had a pattern of stars on a dark blue background painted on its ceiling. And it became so reviled that the term Star Chamber was a pejorative for unfair judicial proceedings. In colonial America, the Star Chamber became a potent symbol of a tyrannical ruler. And so the founders wanted to guarantee against any attempt to use the courts as an instrument for political persecution. Another part of the Sixth Amendment says that the accused will be judged by an impartial jury of the state and district where the crime shall have been committed. Now, trial by jury had already been established in England by the 13th century. American colonists depended on juries for justice, independent of the crown. And so Americans were outraged when Parliament allowed colonists to be tried in courts without juries for violating the Stamp Act of 1765. And so depriving colonists of trial by jury was cited as one of the grievances listed in the Declaration of Independence. The Declaration of Independence listed 27 specific abuses committed by King George III and Parliament against the colonies. And as you can see, one of the grievances was removing the right to trial by jury. Now, the federal government requires a 12-person jury to render unanimous guilty verdicts in criminal trials. Now, states can have smaller juries that render verdicts that are not unanimous, except in death penalty cases. And so a state jury can have as few as 6 members. But with such a small number, there must be a unanimous verdict. Most criminal cases never go to jury, but rather they are resolved through plea bargains in exchange for reduced sentences. 90 to 95% of federal and state criminal cases end with plea bargains. The Sixth Amendment also requires that juries be impartial. And so attorneys to each side can challenge a prospective juror if evidence indicates that the juror is biased. That is done in a process called voir dire, which means questioning potential jurors. Now, to secure an impartial jury, the jury must be chosen from a representative cross-section of the community. The Supreme Court has ruled that particular groups, such as African Americans or women, may not be systematically excluded from the pool of potential jurors. But only the jury pool, not the final jury, has to be representative of the community. And the jury must be local, wherein the crime shall have been committed. And that is done to prevent the British practice of carrying Americans across the sea to be tried by unsympathetic British juries during the colonial days. But a defendant can waive his or her right to a local jury and request a change of venue for the trial if the community is biased because of pre-trial publicity. And also, the Sixth Amendment says that the accused must be informed of the nature and cause of the accusation. The Sixth Amendment gives defendants the rights to know the charges against them so they can prepare a proper trial. This is a major element of the due process of law. In addition, the defendant has the right to confront witnesses against him. This provision prevents a witness from testifying in secret against the accused. Through the process of cross-examination, the defendant can challenge the truthfulness of a witness's testimony. But there are limits to these rights. And so, for example, a witness can refuse to answer certain questions because of a privilege, such as the confidentiality of a confession. The Supreme Court has ruled that a witness must be available for cross-examination by the defendant, but is not compelled to answer all questions. Now, some states have laws that permit alleged victims in child abuse cases to testify without directly seeing the accused, such as on closed-circuit TV, to protect children from the trauma of physically confronting their abuser. The Sixth Amendment also says that there must be a compulsory process for attaining witnesses in his or her favor. Now, the state can issue a subpoena to compel a witness to testify in criminal cases. President Nixon was subpoenaed during the Watergate to produce tape recordings of White House conversations. President Clinton was also subpoenaed in his impeachment trial. But Robert Mueller decided not to subpoena President Trump because he wanted to avoid a long legal battle, and that would also delay the completion of his investigation. So instead, you may remember, Trump submitted to written questions, and Mueller concluded that information obtained from other sources made it unnecessary to subpoena President Trump at that time. The Sixth Amendment also says that defendants have the right to the assistance of counsel for their defense. So in this cartoon, the accused said, "I have a constitutional right to represent myself." And the judge says, "I have a constitutional duty to advise you that exercising that right makes you look like an idiot." So it's never a good idea for the defendant to represent himself or herself. So this right to counsel is the most important of the 8 rights included in the Sixth Amendment, because without it, a defendant would not be able to assert any of the other rights that he or she has. It includes the right to a court-appointed lawyer if the defendant cannot afford one. But until 1963, the right to counsel did not extend to trials in state courts. It wasn't until a Supreme Court decision in Gideon versus Wainwright that indigent defendants were given the right to counsel in any case in which the defendant could be imprisoned if convicted. So in the case of Gideon versus Wainwright, this was a case that occurred because of an incident in Panama City, Florida, where the accused stole 12 bottles of Coca-Cola, some cans of beer and whiskey, and about $65 from the cigarette machine. Because Clarence Gideon was too poor to hire a lawyer, he asked the state of Florida to appoint a counsel, and the state of Florida refused his request. He was found guilty. And while he was in prison, he appealed his conviction, and the appeal was upheld. And from that point on, all accused in federal and state cases have a right to an attorney. In Escobedo versus Illinois, the Supreme Court ruled that a defendant's right to counsel applies during police questioning as well, not just at a trial. So if a person is being questioned by the police in a police precinct, that person has the right to an attorney. The Seventh Amendment to the Constitution states that in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Thus, whereas the Sixth Amendment protects the right to a jury trial in criminal cases, the Seventh Amendment protects that right in civil cases. Civil cases are lawsuits deciding disputes between private parties over non-criminal matters, such as personal injury or disputes concerning contracts. So such civil trials need only a minimum of 6 jurors, but they require unanimous verdicts unless the litigants stipulate otherwise. But the right to trial by jury in civil cases, they do not apply to the states where civil cases might be decided by a judge. The Eighth Amendment to the Constitution reads that excessive bail shall not be required, nor excessive fines be imposed, nor cruel and unusual punishment inflicted. The Eighth Amendment comes almost word for word from the English Bill of Rights of 1689. The purpose of bail is to guarantee that a defendant will appear in court, but the Eighth Amendment does not give unconditional right to bail. Bail may be denied in capital cases, or if the defendant has threatened a witness, or if the defendant has been deemed a flight risk. The Eighth Amendment prohibits punishments that are cruel and unusual, but it doesn't specify what exactly is considered cruel and unusual. Certain punishments that were acceptable when the amendment was ratified, such as whippings or the cutting off of ears, that is no longer permissible today. Now, the Supreme Court has ruled that prohibitions on cruel and unusual punishment must draw its meaning from evolving standards of decency. Now, there has been a long debate over whether capital punishment constitutes cruel and unusual punishment. Opponents of capital punishment argue that African Americans are disproportionately sentenced to death, far more than whites. They point out that since 1973, more than 160 people had been released from death row with evidence of their innocence. Defenders of the death penalty, on the other hand, argue that the threat of execution influences criminal behavior more effectively than imprisonment does. In general, the Supreme Court has held that the death penalty should be used only for the crime of murder, but with limitations. Only if the guilty person is age 16 or older. And in 2002, the Supreme Court ruled that capital punishment for the mentally retarded is now considered unusual and violates the evolving standards of decency of the Eighth Amendment. Now, the Ninth and 10th Amendments are very different from the first 8 amendments. The Ninth and 10th Amendments, the first 8 amendments bestow rights on individuals that the government can't take away. But the Ninth and 10th Amendments refer to rights not specifically listed in the first 8 amendments. And so the Ninth Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." In other words, just because a specific right isn't listed in the Constitution, it doesn't mean that you don't have that right. During the ratification debates over the Constitution, some opponents of ratification complained about the absence of a Bill of Rights. In response, supporters of the Constitution argued that a Bill of Rights would be dangerous. By enumerating or listing any rights, that might imply that all those not listed were therefore surrendered by individuals. And because it was impossible to enumerate all the rights of the people, a Bill of Rights might actually be construed to justify the government's power to limit any liberties of the people that were not enumerated in the Bill of Rights. Nevertheless, because the demand for a Bill of Rights resonated with the public, Federalists like James Madison countered with a pledge to offer amendments after the Constitution's ratification. And so the Ninth Amendment was included to assert that American people have more rights than just those specifically listed in the Bill of Rights. In other words, the rights of the people are not limited to just the rights listed in the Constitution. But whereas the first 8 amendments, which are very specific, such as the right to assembly, speech, religion, trial by jury, the Ninth Amendment is more general. It refers to other rights not enumerated in the Bill of Rights. So what exactly are those other rights? The Supreme Court has recognized the right to travel, for example, the right to privacy, and the right to vote, among others that are not specifically listed in the Bill of Rights. Now, the right to privacy is one of the most controversial rights not specifically listed in the Bill of Rights. The Supreme Court has recognized many aspects of the right to privacy, including the right to marry and the right to have children. In Roe v. Wade in 1973, the Supreme Court cited a woman's right to an abortion as one of those rights to privacy. Most of the significant Supreme Court cases where the Ninth Amendment was invoked have to deal with the right to privacy regarding sexual relations. The 2 most noteworthy cases in this regard were Griswold versus Connecticut, which was a case where the court struck down state laws prohibiting the use of contraceptives, and Bowers versus Hardwick, which struck down a state's anti-sodomy laws and upheld the right to sexual privacy. The first 9 amendments refer to rights of individuals. The 10th Amendment refers to the rights of states. It reads that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are therefore reserved to the states or to the people. And so any power that is not given to the federal government in the Constitution is reserved for the people or for the states. So the 10th Amendment helps to define the concept of federalism. That is, the relationship between federal and state governments. And so under federalism, there are specific powers granted to the federal government. And those specific powers can be found in the body of the Constitution. But any power that is not specifically listed in the body of the Constitution is reserved to the states. And so, for example, there is nothing in the body of the Constitution that refers to the power to control education. And so, education is a domain left up to state governments. But there are also powers that both the federal government and state governments share. And so, for example, both federal and state governments have the right to borrow money. And so there are federal bonds and there are state bonds. Both federal and state governments have the power to build roads. And so we have interstate highways that are paid by federal funds. And then we have state roads, like the 22 is a state road paid by state funds, whereas the 405, an interstate highway, is paid by the federal government. Now, let me just go back here for a second. The 10th Amendment was included in the Bill of Rights to ease fears that the new national government might seek to exercise powers that it was not specifically granted, and that the states might not be able to exercise fully their reserve powers. But the debate over powers delegated to the federal government and powers reserved to the states continued throughout American history. At times, states have claimed the right to nullify federal laws. And at times, states have claimed that it has the right to declare acts of Congress unconstitutional. This is what is called the doctrine of nullification, that states have the right to nullify or reject a federal law that the states consider unconstitutional. Now, that has been invoked at times to insist that states do not have to adhere to federal law, such as when Southern states protested the Brown versus Board of Ed decision. Southern states argued that since education is the province of state and local governments, that states have the right to maintain segregated schools. And as a result, President Eisenhower and then President Kennedy called on federal troops to enforce an end to school segregation. America's greatest crisis, the Civil War, was fought over the rights of states versus the power of the federal government. And all of this is encompassed in what states claim is their right to override federal law. And time and again, the Supreme Court has ruled that states do not have the right to override federal law or to declare laws unconstitutional. Now, the 11th Amendment to the Constitution states that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Article 3, Section 2 states that the judicial power of the federal government extends to cases between a state and citizens of another state. Now, many states did not want to ratify the Constitution because of this, since they didn't want lawsuits against them in federal courts by citizens of another state. But the defenders of the Constitution assured the states that they had nothing to worry about because the states would be protected by the doctrine of sovereign immunity, which declares that states are sovereign and therefore cannot be sued without their consent. But in 1793, in a Supreme Court case, actually realized the worst nightmare that states had. The case was Chisholm versus Georgia, in which the Supreme Court upheld a default judgment against the state of Georgia for failing to pay a Revolutionary War debt to a merchant who had supplied clothing to soldiers from Georgia. And in this Chisholm versus Georgia, the court ruled that sovereign immunity applied only to the federal government, not to the states. Therefore, citizens could sue states without the consent of states. And so states protested this ruling. And in 1795, Congress then passed the 11th Amendment that reversed the Chisholm versus Georgia ruling. And so the 11th Amendment specifically prevents a state from being sued by individuals from another state, although it does not prevent the United States government or another state from suing another state in federal court. Now, let us move to the 12th Amendment. The 12th Amendment changed the way the president and the vice president would be chosen. Under Article 2, the Electoral College originally voted for two people without distinguishing between president and vice president. And the person who received the most electoral votes became president, and the runner-up became vice president. But as political parties developed, problems emerged. In 1796, John Adams of the Federalist Party was elected president, but the runner-up was Thomas Jefferson of the rival Democratic-Republican Party. And so we had a president from one party and a vice president from an opposing party. So to prevent that from happening in the future, the 12th Amendment required electors to vote for president and vice president together on separate ballots. The amendment also states that if no candidate gets a majority of electoral votes, then the House of Representatives, choosing from among the top 3 vote getters, would determine who would be the next president. To choose a president at that point, the House would vote by state delegation, with each state having 1 vote. Now, this has happened only twice in American history, where the House of Representatives has chosen the president. It happened in 1800, when the House of Representatives chose Thomas Jefferson, and in 1824, when it chose John Quincy Adams. Okay, so that concludes this lecture on Amendments 5 through 12. Next week, in our final lecture, we will take a look at the 3 Civil War amendments, Amendments 13, 14, and 15, and we will examine all the remaining amendments, including the 25th Amendment that certainly has been in the news. So at this point,